Afternoon. I'm happy to offer a big welcome from the League of Women Voters of Manatee County to everyone attending today. My name is Helen Anderson. I serve as the chair of the Social Issues Action Team. Our team has been working together to research and understand the topics of affordable housing and homelessness in Manatee County so that we can educate and advocate for solutions that ensure a strong and stable pathway to affordable housing. One area that has had a big learning curve for many of us is land use, planning, and development. And we're incredibly grateful for our two speakers today who bring their deep knowledge and experience in this field and in the county to teach us some of the basics so that we will feel better equipped to participate in discussions and provide our input into decisions happening in county commission meetings. We welcome Commissioner Benac. Betsy Benac is a Manatee County resident who served 2 terms as the at-large County Commissioner of District 7, first elected in 2012 and then re-elected in 2016. Her county experience began as an assistant planner for Manatee County Planning in 1983 and continued until 1994 when she served as the assistant planning director. In 1994, she was hired as the planning manager for engineering, survey, and planning firm Wilson Miller. After 18 years with the firm and rising to the position of principal and vice president with the company now known as Stantec, Betsy decided to take a position with Benderson Development. Wanting to continue to serve her community, Betsy answered the call to seek office as a county commissioner, challenging a 20-year incumbent. During her tenure, she was elected chair of the commission 3 times, served continuously on the Sarasota-Manatee Metropolitan Planning Organization and the Tampa Bay Area Transit Authority, as well as other assignments. Betsy decided not to seek re-election in 2020 and has been enjoying volunteering and family time, including 2 adorable grandchildren, 2 grown children, husband Bob of 40 years, and staying aware of what's happening in Manatee County. We also welcome Commissioner Servia. Misty Servia is a lifelong resident of the Sarasota-Bradenton area. Misty's career includes 12 years with King Engineering as a certified planner in the private sector and nearly 18 years as a county planner. Misty is a past local director for the American Planning Association, or APA, in the state of Florida, the past president of the Gulf Coast chapter of the Florida Planning and Zoning Association, which also honored her with awards for meritorious service and outstanding innovation. In 2013, Misty received a gubernatorial appointment to the Manatee County Housing Authority. She's a former member of Bradenton Tree and Land Preservation Board and the Charlotte Harbor National Estuary Program. And she currently represents Manatee County with the Metropolitan Planning Organization. Misty is a graduate of Florida State University. She and her husband, Joaquin, have 3 children, Alexandra, who is a local mental health counselor, Joaquin, who's in the U.S. Navy, and Mark, who's in the U.S. Army. Before I turn it over to Misty and Betsy, I wanted to give you an idea of what to expect as an attendee. The first 45 minutes of our call will be focused on presentation, with the second 45 minutes saved for Q&A. As the presentation goes on, please feel free to put your questions in the chat. You will have to make sure that it goes directly to me as the co-host. Again, my name is Helen Anderson. I will organize and share as many of these questions as possible during our Q&A portion. Alice Newland, my co-host today and our lead president, will be helping me to monitor the sound. We may use the mute function to prevent any background noise from disrupting an attendee's ability to hear, and we thank you in advance for your understanding if we do have to mute you. I also wanted to let you know that we have a closed captioning option, so if you prefer to use that option and read what instead of hear, you can click on the Show Captions option at the bottom of the Zoom call. Misty and Betsy, we thank you for being here, and I turn it over to you.
Okay. Thank you very much. I decided, since I'm the senior planner of our team, that I would go ahead and start out. If you want to go ahead and put the PowerPoint presentation up, we can go ahead and begin. All right. First of all, I know Misty and I want to thank the League of Women Voters for hosting us today. We've had some discussion. We know that the people in Manatee County, and we are going to focus mostly on Manatee County because quite frankly, that's where Misty and I, that's where our background is in being planners. As you stated, I started planning in the state of Florida in 1983. Before that, I was a regional planner in Michigan. When I graduated, I have to say I graduated from the University of Michigan. I didn't put that in, but I always like to give a shout out to Go Blue. So I don't have any initials after my name. I was a member of the American Institute of Certified Planners, but when I became a county commissioner, I did let that lapse. Simply because it does require extensive continuing education and also payment. So I did not continue that. Misty, of course, is still active, very active planner. And so she is an AICP. So we'll go ahead and go to the next slide. All right. So basically what we wanted to go over is kind of a growth management background. Where does growth management come from in the state of Florida? Again, we're focusing mostly on the state of Florida and in Manatee County, some of the trends, some of the reasons why growth management even came about in the state, the process of development. Misty's going to go over that. So I think some of you are familiar and some of you aren't. The process of development, where you can be involved, and especially today, what are some of the areas where you can have involvement? How do you get involved in the rezoning and the comprehensive plan? So we're going to go through that in a few minutes. Okay, next slide. All right, so this slide is basically the history of Florida. I was doing some research about Florida, and one of the things I found that was interesting, that Florida was the last of 48 states, and of course this is a while ago, to adopt a standard state zoning enabling act when the state delegated zoning powers to local governments in 1939. So zoning has been around for a long time, right? Zoning, again, was something that was basically a public health issue. But Manatee County began to really experience significantly growth in the 60s. So one of the first things that came about was the 1968 Comprehensive Development Plan for Manatee County. Again, this was not something that was mandated by the state. This is something that the county did on their own. So we're going to take a look at that in a minute. The next thing that happened in the 1970s, that's when Florida's growth really took off. So in 1972, Florida was the fastest growing state in the country. So in the 1970s, you started to see the state start to get involved. The first thing they got involved was something called the Florida Environmental Land and Water Management Act. Water's always been a big issue in Florida, whether it's too much water or too little water. I served on the Minnesota Basin Board, which was a subset of SWPMA, the Southwest Florida Water Management District, that also came about in the 70s because the idea was you had flooding that was going on in Florida, but you also had huge droughts that were happening in the 70s. Big droughts in the Everglades, fires, if some people remember. So that was kind of the impetus for the state to get into the Planning Act. So one of the first things that happened in the 1970s was the Florida State Comprehensive Planning Act. So the state has decided at this point to take a role. And that was not unusual in the country, that the states were taking a role in planning and kind of looking at how do you correspond with that. So that was legislation, excuse me, that was passed in the early 70s. Following that, the 1973 growth policy for Manatee County. This is a very interesting map. We're going to look at it a little bit. This is planning for urban growth. I believe that's what the acronym stands for. I honestly have no idea what the O stands for. I don't know if Misty does. Maybe she could clarify it. But this growth policy, again, very interesting how forward thinking this was, because you can see some of the lines that we still have today in our comprehensive plan on this very early planning document. And again, the 70s, again, the state was still very, very involved in the planning process. And then in 1975, I think it's the next one, the Comprehensive Planning and Land Development Regulation Act. Again, that was state legislation. And it said that all the counties would have to adopt a comprehensive plan by 1979. Interestingly, it really didn't get enforced much. Some did, some didn't. But there again was significant state direction. And that's really, I think, in 1975, when you started having this idea that Florida was a state down planning state, meaning regulations developed at the state, local governments had to comply with them. And then again, growth is continuing. The biggest one is the 1985 Growth Management Act. That's the one that mandated the plan that we currently have now, interestingly enough. It was 1985. Again, you had a time period when all local governments had to create a local comprehensive plan, very, very prescriptive standards in the state law that the local governments had to comply with. Manatee County did so. They adopted their comp plan basically in 1989. I don't know if that's the next line or not, I can't remember. Yes, it is, good. The 1989 Manatee Comprehensive Plan. I will tell you that Manatee County won an award for their comprehensive plan. And that comprehensive plan is significantly still the same plan that we use today. It has been updated. Of course, there's been many, many changes at the state level, legislative changes, so many different things. We'll go through some of them. You know, it's kind of an ebb and flow kind of a thing with state planning. You know, regulations come into being, regulations go away. And it actually is kind of a challenge for the local governments, and this includes cities, have to keep up with this legislation and are required to update their comprehensive plan every 7 years and show that they're complying with these regulations. So 1989, Manatee County, they hired a consultant. I was there at the time. I didn't have a whole lot to do with it other than trying to update the zoning map, update the future land use map to comply with the Manatee County Comp Plan in 1989. And the zoning code followed in 91, I believe. Okay, next. All right, so during the 80s, the early 2000s, really till 2007, you still had a very strong state presence in comprehensive planning. Very top down, very regulatory. But remember what happened in 2007, 2008? We had the Great Recession. For the first time, I think the state of Florida was facing a period without huge growth numbers. People had to react to that. The legislator react. They said, you know, we're really gonna change this. And in 2011, the Community Planning Act was adopted, wiped out significant portions of what was previously in the comprehensive planning land development regulations at the state level. Again, the county complied. County came into compliance with that, and that's pretty much where we are today. I think that's the last line. So next slide. All right, so why did we get into all these regulations to start with? Well, Florida was growing, but Florida, as we know, is a very sensitive environmental state. So, you know, where did all those finger subdivisions came from? Well, you could do it. You didn't have any regulations. So again, it was mostly environmental reasons that state planning came into being. It wasn't because of roads necessarily. It wasn't because of, you know, population increases per se. It was because people were reacting and there were concerns about how these significant impacts to the environment, how should they be addressed? And so, you know, if you want to read Florida's history, you can see it's always been about the environment. This plan is a great one. This is one of the early ones. This is the concept development plan. What I love about this, very old map. Again, this was one basically the county did on their own. Oh, you're going too fast. Back one. I just want to point out some things for those people that, you know, think we don't have enough bridges. Well, you're right. We never built all the bridges that were on this plan. Look at that plan with the bridge going from West Bradenton next to Robinson Preserve over to Sneed Island, up into Terracea. I guess we probably don't need to ask why that didn't happen. Kind of would have been surprising if it had, but there was a true grid system. There was also the bridge that we all say, whatever happened to that bridge, that other bridge across the river? Well, I could tell you stories about bridges in Manatee County, and it sounds like a great movie. But the fact is that we never built the bridges that were planned. Building bridges is hard, costs a lot of money, it's environmental problems, and people don't like major roads running by their house. But it wasn't because they weren't planned. So I thought that this is an interesting graphic to show you. Let's go ahead and go to the next slide. All right, this is that OPUG that we were talking about. What I think is really interesting, this is in 1973. And you can see this was helping to establish county utilities. Manatee County had county utilities at a very early stage. That was not the norm. We were kind of out front with that. Some of you know that Sarasota County decided not to do public utilities on a countywide basis. It was a choice they made to not pursue that because they were afraid if they did those kind of utilities that it would lead to growth. Well, the reality is growth happened, but you didn't have the utilities. Manatee County, by seeking out funding, there was lots of funding available at the federal level for utilities. The Environmental Protection Agency came in, helped Manatee County to develop the utility system, the wastewater systems in the western part of the county, because we had issues. We had blooms in Sarasota Bay. So we were able to get funding from the EPA. I mean, it's maybe not a great record, but in fact, we did put in the type of wastewater treatment systems to prevent that from happening. But what I think is really interesting with this is you can look at the red line is basically where the future development area boundary was set and still is set today, by the way. At one time, well, actually, I should take that back. That's not really where it is. It actually goes through Lake Manatee. But you had this idea back then, that was all rural. To the east of the red, where the red arrow is, you had an urban fringe area, you had a growth area, and you had an urban area. So that, I mean, 1973 is going back there. But I used to joke that the #1 planner in Manatee County was a guy named Dick Wilford because he was the utilities director. You know, you're going to build a large utility system, you got to have customers. And so that's why Manatee County planned for that growth by building this utility system, funding it through contribution, and I shouldn't say contributions, funding them through fees that were charged to development, to fund it, to keep it up. Those fees are still in place today, by the way. Not updated very recently, but they're still in place. Next slide, please. All right. So here we are. We've been through a lot of very early planning exercises. As I said, 1989, you were updating that every 7 years. The state was going back and forth. What was the state's role? State's role was basically to look at significant state resources, very large projects. Large projects are called DRIs, Development of Regional Impact. And that was kind of what the state was focused on prior to 2007. And the reason was that development of regional impact meant just that where you would have a large development, I'll use Palm Air because it was the first DRI in Manatee County, and I think most of you know where Palm Air is. So Palm Air was one of the first DRIs in the early 80s to come about. And what it said is you had to look at the impacts of the development, how it impacted Sarasota County. And you had to get approval, and Sarasota County could appeal it. Interestingly enough, Lakewood Ranch was a similar DRI situation because you had large areas in Lakewood Ranch that were being developed and large in Sarasota and even large areas in Manatee County. Both of them had DRIs. That was the way that planning was, again, from a top-down perspective, the state regulated this process. The regional planning councils had a role in that. You know, we're part of the Tampa Bay Area Regional Planning Council. In 2011, that basically all went away, okay? What the legislature said is that, and this was under the leadership, I think Rick Scott at the time had been elected, it was going to say, look, local governments have plenty of resources, they can do their own planning. We don't need to be involved at the state level, and you don't need input from the regional level. So that was a big change. Some of these became sector plans, again, kind of a mini development of regional impact process. The idea, again, that you're looking at large developments. So sector plans were more in favor in places like Pasco County, in places like Sarasota County, places that didn't already have DRIs in place, because the DRIs that were already approved stayed in place. I believe Lakewood Ranch still is a DRI. Terra, for example, is still a DRI, Development of Regional Impact. The only way you get out of the DRI process is if you petition to abandon it. And DRIs, just any kind of a plan approval that you get from the government, it grants things and it requires things, right? That kind of a development order. So some people don't want to get rid of their DRI approval because it grants certain, it basically locks them in for what the rules were at the time. And that could be valuable. So not all DRIs went away. It also changed significantly the process for comp plan amendments. Prior to the 2011 Act, you were very limited, local government, when you could do comprehensive plan amendments. The process was much longer. You could only do them twice a year. The idea was that comprehensive plans were not supposed to be amended on a regular basis. And if you look back prior to 2011 to the number of comprehensive plan amendments that were done in the county, and they kept track of them, you'll find there were very few comprehensive plan amendments. You really didn't get big changes. Remember, in 1989, when the comp plan was adopted, you had a change, a significant change in the Manatee County Comprehensive Plan, where prior to 1989, you had a limit on development that was basically I-75. But then we created the urban fringe. You went from what was 1 unit per 5 acre maximum east of I-75 to 3 units per acre maximum, all the way out to where the future development area boundary ran through basically through the dam at Lake Manatee. If you go north-south and you have it run a north-south line running right through the dam at Lake Manatee, that is kind of where today's future development area boundary is. So you didn't really need that many comprehensive plans. What you had were a lot of rezones, bringing the land that was zoned agriculture up to a maximum of 3 units an acre, because that's what it was, the UF3 area, all the way out to Lake Manatee. You had plenty of land. You didn't get a lot of comp plan changes, very small ones. And even those on a small scale, you didn't have to copy anything to state. You had a very expedited review. And then concurrency. And I haven't really talked about concurrency. Let me explain a little bit what concurrency is. So concurrency was something that was brought about, again, all the way back in 1985. The idea being that any development, their impacts had to be concurrent with the resources to handle the impacts. Roads, schools, they all had to be available, parks. You had to have the resources available in order to get the development approval for those impacts. That's concurrent resources with the impacts. It sounded like a great idea, but I will tell you, having experienced it, what really happened, I'll just give you an example on roads. What happened in Manatee County was, and this wasn't unusual, it happened elsewhere, that let's say you have so much gridlock off of 301. So what do? You move out as far as you can to where the gridlock falls off, and then you develop there, and you can get in just under tripping, the mechanism that says, oh, you don't have any more road capacity. So it really kind of backfired a little bit, concurrency. So in 2011, they made it optional. Also, one of the other problems was in some of outlying areas, again, I'll bring up Pasco County because they've seen significant growth in their rural areas as well. Some of the fees, so what you had is you had a pay and go that came about in 2011. Some of the fees were astronomical. I remember I worked on a development of regional impact in Northport, right? I think most of you know Northport is an area that had all of these old platted lands, and you really didn't have any major planned developments. Everything was just platted lots with no water, no sewer, and everything was on septic tank and well. And someone decided that they would put all this land together and do a master plan community, golf course community and it was called Heron Creek. So we were under this new standard of concurrency, right? And one of the requirements that they had was they were going to have so much development that had never been looked at before. Northport has all this development, but you had to include everything that was there. And it said they would have to add a lane to the interstate. Well, that was kind of ridiculous. No developer is going to add a lane to the interstate. They don't even have control over it. So that kind of backfired. Concurrency now is optional. It's still, still a big question. What does concurrency get us? I don't think there's much of an application in Manatee County at all for concurrency, even though we still have it. Evaluation and appraisal report, that's called an EAR. That is something that, again, was required by the state every 7 years to make sure our comprehensive plans were still meeting the state laws. That review was significantly dropped. Okay, so there's not much of a process for evaluation and appraisal review, other than if the state changes the legislation, Florida statutes that apply to the comprehensive plan. When you do your evaluation and appraisal, you have to come into compliance with those new laws. That's basically what it's for. Financial feasibility requirement for comp plan no longer required. Again, this financial feasibility requirement was something that was put in there. It was very, very difficult to comply. You know what? And this is actually one of the big questions you have in comprehensive planning. What are the costs? What are the costs to the local government? What are going to be the costs to the taxpayers that are there? So this was a requirement, and it just never was really fleshed out. So it went away in 2011. So I'm going through this kind of quick. It's really to show that the Community Planning Act of 2011 was a very big change for local governments about how they basically did things. Our comprehensive plan in Manatee County did not change a whole lot, quite frankly, because you know, we didn't have sector plans. We didn't have that many comprehensive plan amendments. So, but it kind of was the beginning of a lot of changes. So if you guys have questions, I'll try to answer them in the question and answer. So go ahead and let's go to the next slide. All right, Brevard versus Snyder. So this is an interesting case. I am not a lawyer. Neither Mr. are lawyers. There's great land use lawyers in town, but like any kind of law that is applicable in the state of Florida, that it is affected by case law. So this is the case law that I think maybe kind of frustrates many people in the public, but it is the case law. So Snyder was a petitioner for a rezone in Brevard County, came forward with a rezone request. Initially the county, I think he had some property that he was going to change from single family to multifamily. Initially the county said, okay. Actually initially they said no, and then they provided some additional information. It was in a floodplain. They tried to say no, and then they said, well, we're going to elevate out of the floodplain. So that's not an issue. So the went back. The state said, okay, or the staff said, okay, you've met the standards of the comprehensive plan. It was permitted in the comprehensive plan. Again, zoning must be consistent with the comprehensive plan. Comprehensive plan is the big picture that we've been talking about. Now comes zoning to implement the comprehensive plan. Most places like Manatee County didn't change all of their zoning maps when the comprehensive plan came into being. They changed the comprehensive plan, future land use maps, but zoning has to go through individually a rezone. But if you are consistent with the comprehensive plan, you're meeting the standard, right? So this Brevard versus Snyder was done in the early 90s. The standard back then was still what's called legislative. So legislative means that you've got a lot more leeway. I know there's some attorneys on here and you can correct me exactly what this means, but the it is I'm gonna read it, fairly debatable standard, right? Okay, So local government, and in this case, what happened is all the neighbors came out and said, we don't like this. It's going to increase the traffic. The local government did deny the rezone. Snyder sued. This case went all the way up to Florida Supreme Court. It was decided that no longer should the standard be this fairly debatable legislative standard. You got the comp plan that was done legislatively, but if the rezone comes in and complies with the comp plan, the local government cannot just deny this. And it is now a judicial, quasi-judicial process. It is a judicial standard. And this went back and forth. One of the things I thought was interesting in this case, the local government says, this impairs our ability to respond to public comment, this decision. They weren't wrong. The fact that it becomes quasi-judicial means that the local government, in considering a rezone, has to act like a judge. The decision has to be based on substantial, competent evidence, expert opinion. So everyone that gets up and says, you're my commissioner, I don't like this, I'm not supposed to listen to when I'm a county commissioner. You have to show a legitimate public purpose. It's not arbitrary, reasonable, or discriminatory. This is a pretty big decision that affected how land use and zoning is regulated. So, and consistency with the comprehensive plan. You aren't automatically granted the highest that you can get in that category. You still have many standards in the zoning code. Misty's going to go over that a little bit more. But it isn't arbitrary. We cannot just say, well, I'm your legislator. I am representing you. Therefore, I'm going to act on what you're asking me to do. No, I got to act like a judge. And you can't talk about, I think that's actually the next slide. Let's go to the next slide. Oh, I don't know why we jumped to population projections. But anyways, you can see population projections where we are. I think what's really important about this, and you can see that Manatee County is continuing to grow. There's no reason to think that we will not continue to grow. But I think what's really important is what effect do these population projections have on planning. So you can see the source up there in the corner. It's the Bureau of Economic and Business Research, what we call BEBR for short, April 2020 medium projections. So state law requires, I believe it still does, it's been a while, but I'm pretty sure it still requires that we use, Manatee County or any local government, use these BEBR numbers, these projections when doing planning. I will tell you that these numbers need to be checked occasionally. As I remember, I told you Sarasota County didn't want to plan for growth because they didn't want to have growth. They thought they liked it just the way it was. A lot of people at the time, they used the BEBR low numbers, low projections. You have that ability to do that. Well, the fact of the matter is growth happens whether you plan for it or not sometimes, right? So it is important to check these projections. These projections are used in everything for planning for our water supply, planning for our utilities. Yes, planning for growth, but the growth is you have to have at a minimum, you have to be able to accommodate the growth, but you could have a huge percentage of what's called a marketable market factor. So when Manatee County projected for growth in 1989 under that 85 law, it was a 300% market factor that they built in. So the idea that there wasn't enough land to handle growth in 1989 is simply not true. It was a 300, I was told, a 300% market factor at least built into the comprehensive plan. So you have to have this as a minimum, but you can plan for a lot more if you want. Next slide. And it needs to be checked, like I said. Things change, right? Things slowed down significantly during the recession. Things are picking up again. Misty, tell me when you come in, because I can't remember exactly. Are you in now?
Yeah, this is the slide. Thank you, Betsy. You did a fantastic job on the history. So since we've been going for about 30 minutes, I am going to try and quickly go through these slides so that we can get to your questions, but I hope I can still explain them. So as Betsy touched on, for concurrency, Manatee County still has concurrency laws, but they are a little bit different. For example, you don't have to count what we call background traffic. So for people that wanted to develop on a roadway that was already congested, they only have to account for their traffic that's related to their development. And concurrency is issued at the final stage of the process. So not until final site plan. So these colors that you see on, or generally with final site plan, the colors that you see on this map are projects that are either built or have concurrency approved, and that means they will be built in the near future. Next slide. Okay, and this is kind of a flow chart of the process. Everything begins with the comprehensive plan, and the comprehensive plan should be the goals of the community for the future. That's really what the comp plan is. And if you imagine yourself at the 30,000 foot level, it's a very broad-based document. Then what we do is we have a land development code that brings in some more of the details, like the zoning and the development standards and subdivision laws and concurrency and site planning review. And only after you go through that process can you begin what we call horizontal construction. Those are the roads, the pipes, everything underground, and the vertical construction, which are the buildings themselves. Next slide. So what is a comp plan? And Betsy kind of touched on this. And as I just said, it's really the goals of the community and how you're going to grow in the future. The state of Florida has a comprehensive plan that it's only a few pages long, and it's still a requirement that every local jurisdiction be in compliance with the state comprehensive plan, okay? And again, this document has many different chapters that are mandated by the state, including those on the slide: housing, how we're going to coordinate with other cities, how we're going to manage land use and growth, a solid waste component for, our landfill, for example, transportation requirements, and utilities. It also establishes minimum levels of service. And if we didn't touch on that, a level of service says, a certain infrastructure, let's say a roadway, must operate at level C or D or F. It's just like the grades you got in school. And if it falls below that, we've got a problem, and that facility has to be upgraded. So the comp plan establishes those levels of service for all of our infrastructure. Next slide. Okay, and so as a part of our comp plan, we have a map that outlines the future land use for all the property in the county. And that's what this map is showing you. So again, this is showing patterns. It's showing, what we can expect over the life of the comp plan for development. And you'll probably notice that there's a lot of green area, which is agricultural, on the eastern side of the county, and all of the colors are west of that future development area boundary, because that is where the comp plan prescribes that development will occur, and it will not occur east of that boundary. And that's changing just a little bit, as those of you who are paying attention to local decisions have probably noticed. Okay, next slide. Okay, and this is, I'm trying to see can't see the whole thing. So I think this is future. Oh, this is also future land use. I can't see the title of this, sorry, because someone's commenting.
It's a consolidated
future land. Yeah, okay, got it. So again, the future land use categories, you see all that green to the east, that's all general agriculture. The beige color is where the comp plan has prescribed that residential types of uses should go. The mixed use that you see are probably actual approvals for mixed use development. I see up in the northern area, that maroon color up in the northern area by the gray area is actually a site that Alan Jones at one time had asked for some mixed use future land use category. Today it's still in farming, but eventually he wants to develop there. And so it just kind of gives you, again, an idea of those patterns of development that the comp plan is prescribing. Next, please. Transportation. So this is another map that we have in our comprehensive plan. And this is a map that shows you the existing major roadways that we have and the planned major roadways, again, to handle the growth that's needed in the county. So the dashed areas, I don't know if you can see it at this scale, but there's some roadways that are just dashed lines, like I can see the extension of 44th is a dashed line, and that shows you those roads that are needed and how many lanes are needed for all of the development that is governed under the 2030 comprehensive plan. So this map was done to take us into the year 2030. Next slide. And what is the land development code? So this is where we bring in the details. You know, land development code implements the comp plan. It's completely consistent with the comp plan. It's, if you imagine a funnel, it's just bringing in all of the details on how we're going to accomplish what the comp plan has prescribed. That comp plan is a vision, and these are the specific thing, and roadways and even impact fees are established by the land development code. Next slide. What is zoning? So Betsy touched on this a little bit. You know, zoning is how we categorize land by the uses that are appropriate. You know, back in the early 1900s, in the big cities, there were problems, like in Los Angeles and in New York City, for example, where there were already lots of people living there, there were problems. And so that was kind of the beginning of zoning, because before zoning, you would have to sue your neighbor. Let's say your neighbor put up a manufacturing plant next to your house. You would have to take your neighbor to court and sue him in order to get some relief. So zoning was put in place to, you know, basically for public safety reasons, but also to protect people. I remember in New York City, you had skyscrapers being built in the early 1900s that were so tall that it would shade out the air and the light from everyone else, and people were upset by that. So zoning's initial goal was to try and control that for the benefit of everyone. Next slide. Euclidean zoning. Okay, so Euclidean zoning is a fancy word for standard zoning districts. Those are the straight zoning districts, like A for agriculture, RSF for residential single family. And these are districts that are prescribed in detail in the code. It says what uses are allowed to go there. It tells you the setbacks of those uses. It tells you even how many parking spaces you're going to need if you develop an office in a commercial district. Euclidean zoning is very standardized, and it's also good for single uses, but it really doesn't foster the mixed use development that is so important for so many different reasons. So there's a lot of pushback on Euclidean zoning. It is changing. There's always talk of zoning rehab and reformation. So I think you're going to see zoning change over the years, and it's a good thing. And there are some things that we need to protect that zoning protects us from. But generally speaking, we want to bring in laws that allow a mixture of uses that can, you know, be compatible with each other and not cause everybody to drive from one point to another to get what they need. And I always tell people, if you imagine like your living room, you wouldn't want all the lamps to be in the left corner and then all the coffee tables to be in the right corner. You want everything to mix together so that you can have the best life. Okay, next slide. Zoning map. Okay, so this is, I think this is most of the county, not all the county, and highlighting the zoning districts. Again, this is good to look at just the patterns. You can see where the development is taking place, where it should take place, and where our code has said, you know, we don't want development out in the east. And that's where all the agricultural land is. And that's really done purposefully for a lot of reasons. You know, not to just manage growth, but to protect agriculture as a viable resource in Manatee County. Next slide. Zoning and transition of development. So yeah, zoning is pretty much set up to transition or step down so that things are compatible with each other. So you see the picture of the concrete batch plant that you might see on US 301. It would be unusual to see a single family home on US 301, right? We have the most intensive uses next to the biggest roadways. And then next to the batch plant, we might have the wastewater treatment plant that you see also on the slide. And next to that, you might have the light industrial building. And next to that, you might have the shopping center. And then next to that, you might have the town center. And then finally, the residential. So that all of those uses that are next to each other aren't impacting each other in a negative way. Next slide. Zoning and transition of development. Again, so the most intensive to the least intensive. And as I just said, with the Euclidean zoning or the standard zoning districts, that's what it intended to do. You know, if we have A1 or suburban agricultural zoning, then next to that, we can put low density residential zoning. And next to that, we could put duplex zoning. But it didn't allow for us to combine some of these uses and separate them and join them together in ways that make sense. Okay, next one. The process of development. So basically there are two tracks to getting approval of development. There's an administrative review process, and that is where the staff will review site plans per the land development code and the comprehensive plan and say, yes, it meets all the standards, it's approved, or no, it doesn't, make these changes, and then we'll approve it. Or the public hearing process, which invites the public to participate. Both of these processes require that you're consistent with the comp plan and the code, but the public hearing process is in place to bring the public's voices into the conversation. Again, you should generally want to do what the community wants for their community. Next slide. All right, again, the process of development, you've got to be consistent with that comp plan, the future land use map, the zoning, the land development code, and lots of other standards. You know, the fire department reviews our plans to make sure that, you know, for fire safety reasons, the engineers review it for their standards. The Southwest Florida Water Management District gets involved. Sometimes the Florida Department of Environmental Protection. So all of the agencies that have a stake in the game are reviewing to make sure that the development that's approved is the best development for the community. Next up. Oh, and Betsy, this is you. Take it away.
Okay. All right. So again, we've gone through all of what a comp plan is, zoning code, and again, we go back to the state's role. And quite frankly, this is the idea of property rights. And I think I mentioned that the law required at one point in time, the Florida legislature said that we had to address, and our comp plan was updated to say that recognize property rights, but property rights are recognized in the Constitution. So it's not really that much of a mandate, but Florida statutes, chapter 163, which is basically the planning statute. If y'all want to read Florida statutes 163, you get an idea of the Florida laws that apply to planning. But the intent is to recognize and respect constitutionally protected private property rights. All rules, ordinance, regulations, plans, programs must be applied with sensitivity to private property rights and not be unduly restrictive. You know, that almost to me goes without saying, but I think it's good to be reminded of that, that is what has to be applied. We cannot just make up rules. We have to respect that private property rights are foremost in the Constitution, that you cannot take somebody's property rights without due process. And I think that might be on the next slide, actually. You want to go to the next slide? This is actually, again, this is an implementation mechanism, if you will. It was done through Burt Harris Private Property Rights Protection Act. So as I said, you know, with these regulations, they kind of ebbed and flowed depending on who was in power at the state legislature, you know, which party, you know, what was going on, quite frankly, at the time. And that's kind of how it's always been in Florida, right? We follow what's going on in the state legislature to see what's happening. Well, this was kind of happening when there were so many regulations that were being applied, and people that have property rights wanted to develop their property. So they were being turned down in some places. You know, there's some places like in Martin County, that would be a great example for people to look. And I was always being in Manatee County, things were not necessarily that way, but it was interesting to see how they tried to tell people things that they couldn't do with their property. I used to joke and say my job as a county planner is to tell people what they can't do with their property. If they told me, thank you, I was doing my job correctly. But the Burt Harris Private Property Rights Protection Act does say that somebody could be inordinately burdened an action of the government that restricted the use of property such that the property owner is permanently unable to attain the reasonable investment-backed expectation. Well, what's a reasonable investment-backed expectation? That has been interpreted in many cases to mean that if the comprehensive plan gives you a designation that says you can transition from agricultural to like a residential, and you own that property and you know that that's what the comprehensive plan, that's a reasonable investment-backed expectation. Again, I'm not an attorney, but that is the way that has been interpreted in many cases, law cases, people that have sued local governments and saying that, you know, I had a reasonable investment-backed expectation when I bought this property that I could use it for this use. You can't just say no. And then the property owner bears permanently a disproportionate share of burden imposed for the good of the public. That basically says that fairness has to be borne by the public at large. In other words, if I say, well, you know, I have this property and I really don't think that my neighbor should be allowed to do this because I like his open space next to me. I love that. I've enjoyed that. I've taken my dog for walks over there. I don't think he should be able to change it. Well, you know what? If that's what you want, then the government better buy it for a park. That's, to me, the interpretation of this. You can't just say, you know, I think this property would be a great place, even for a road. I think this would be a great place for a school. You have to pay to be able to use that property for the good of the public, okay? So the private property rights element, as I said, is now in the comp plan. Again, I don't, this is something that's there, should be aware of it. You can read it, but I don't think anyone would be surprised by reading that. Next slide. Same thing with rational nexus. Rational nexus means that in this Nolan versus California Coastal Commission, I honestly didn't look this up, so I'm going from memory. I believe it was about having a pathway along the beach, and Misty, you can correct me if I'm wrong, but the idea that they would be required to provide that in front of their property. Again, what's the rational nexus? Because they have a home there or they're developing homes that they have to now create a park for the public. They said that's not a rational nexus. It's not connected. Rational nexus, right, being connected. So right. These substantive due process claims shape, again, how your local government interprets the laws. Same thing for rough proportionality. You know, if you're building a multifamily development, are you supposed to build the interstate? no, you're not having that big of an impact. How is it roughly proportional to the impact that your development has? And that again was another way to say that, you know, some of these laws can get a little crazy. You can't just say no, you can't just say you need to do this for me. But things can go both ways, right? But these are kind of laws that created what we call substantive due process, which is the standard that you have to meet as you go through this process. Misty, did you want to add something there?
Well, yeah, if you could go back to that slide, I mean, I'll just add that, you know, these are really important cases, Nolan and Dolan. And, you know, Nolan was from the late 80s, and pretty much what it said was developers have to carry their own weight. They can't impose the costs of their development on the community. And then the Dolan case further refined that. And that, I remember that being 1994, because that was the year I was married, that exactions that are taken must be roughly proportional. Just like Betsy said, you can't ask that someone's going to build a lane on I-75. And, you know, right away for a small development, right away is a good example, because back in the day when Betsy and I were planners at the county, you know, we would get right of way sometimes up front during the rezone stage. You know, it would be conditioned in a planned development rezone that you've got to dedicate right away with at such amount for this roadway. And we just don't get that kind of commitment up front after these cases. Now right away is taken at the final plan stage, and it must be proportionate to the impact of the development. Just because we need more right away for 44th Avenue and this project's on 44th Avenue doesn't mean that we get all the frontage right away for 44th Avenue. It's very prescriptive. And so probably the biggest case under those US Supreme Court decisions was the Koontz case. The Koontz case was in Northern Florida. There was a guy named Mr. Koontz who had 15 acres of property and a lot of wetlands on the site, and he needed a permit for his development. Well, when you have wetlands, Betsy will tell you, you've got to go through, in our area, the Southwest Florida Water Management District. So the Water Management District up there, and Koontz offered them 11 acres of his 15 and said, I'll put a conservation easement on it. I just want to develop on the rest of it. Well, the Water Management District said, no way, we want 14 acres. And if you don't want to give us 14 acres, you could help improve our land that's a few miles away at your cost, and then we'll give you a permit. Well, Koontz said, forget it. He sued the St. John's Water Management District, I think it was. And again, not an attorney, just telling you what I know for all disclaimer. But so when he sued, the district court said, yeah, you know what, Koontz is right, and ruled with him. It went to the appellate court, who ruled the same. And then the Florida Supreme Court said, no way, we disagree. Well, that case later went to the US Supreme Court, and the Florida Supreme Court's decision was overturned by a 5-4 vote. They said Florida was wrong. So those things are taken into account at every development decision now. And this kind of stuff was pounded into us in a good way by the county attorney, so that we had a good understanding of it. Next slide, please. So again, getting back to the procedures, just like Betsy said, the government has to be fair and reasonable. And when you're going through a public hearing process for rezone, you've heard the term ex parte communication. It's a very formal process at that hearing. It's like being in a courtroom. And the commissioners will always say whether or not they've had any ex parte communication. And that means communication with anyone. Could be the Parish Civic Association about a rezone in their area. It could be a neighbor. It could be anyone that they have discussed it with outside of that courtroom, if you will. So very, very formal process. And along with that, it provides an opportunity for people to challenge those things in court. And they are often challenged. And Manatee County has been party to a number of those challenges. Okay, Betsy, I think that now you're wrapping up.
Okay, yeah. All right, so big issue for Manatee County, other counties, timing of growth and development. When should it occur? When should development happen in rural areas? And obviously the biggest question is availability of infrastructure. So this is a big issue right now in Manatee County. As I said, we really have not changed the future development area boundary in Manatee County since it was established in 1989. It was, in fact, there's been some shifts that have happened, some small shifts, things lined up a little bit differently, but there hasn't been a wholesale change until now. Right now, there are three cases that I know of in Manatee County, future development area map amendments that are basically changing this, but without changing the future development area boundary. So this is a test, this was just done in 2021, that there was a policy created that says, if you're adjacent to development, if you're adjacent to the future development area boundary, you can go forward and ask for a expansion. And that policy is being implemented right now. There's something called a Taylor Comprehensive Plan Amendment. It's being in the process right now. There was also the L3 development that also came forward. It was a master planned community, very different kind of community, but it's pretty far out there on State Road 62, outside the future development area boundary, a unique kind of development. They sold it. And what happens is there has not been planned infrastructure for these developments, because the future development area boundary in Manatee County is basically the same boundary as the urban service boundary. So urban services, again, things like water, sewer, schools, parks, all of those kind of things that were basically concurrency issues, as we talked about before, have been planned in the comprehensive plan to serve the future development area boundary. So what's been happening, the way they, this policy that allows growth outside of that said, well, those developments will provide all of their own. And that's the question in my mind. I'll go ahead and just leave it like that, because I don't want to get into a discussion about those, because those are pending. But obviously the major issue for planning is the availability of infrastructure, and not just infrastructure. We're talking urban services, things like I said, parks, schools, libraries. I in my experience at the county, 11 years at the county, and then 18 years working in the private sector, it's pretty standard. People say, I pay my taxes, I'm entitled. I am entitled to have, the ability to drive on a road, the ability to have a fire truck, to have an ambulance, the ability to send my kid to school, to go to a park. That doesn't change regardless of where you live. What does change is who pays for it, right? And availability of infrastructure is generally, we had something called growth pays its own way. That was the idea. So that was the intent. I guess you're telling me I got to finish up because you're moving me forward. Compatibility, Misty went over that in great length, I think, about what compatibility is. But you know what compatibility isn't? And I think this is something that was the intent of this. Single family next to multifamily next to a smaller lot, that really isn't compatibility. Residential next to residential is compatible. Commercial can be compatible with residential. You don't, like, I live in an area where I'm blessed I can ride my bike to go to a commercial. Yeah, you have to have buffering, you have to have step downs, you have to have all the things that Misty talked about. So I'm going to kind of just skip over that, and we'll go to the conclusion. So this is the conclusion. Right now, we're currently in this process where our state laws continue to smooth the process for development to go forward. We're a very, very growing state still. Environmental issues are still extremely important. Roads, I don't have to tell you guys, you all know what the situation with roads. I will tell you that impact fees came into being in Manatee County in the 80s. Impact fees by law cannot be used to resolve existing deficiencies. Manatee County came into, and a lot of places came into a hole, right? They started out with existing deficiencies. By law, you can't change that. So you had this idea that you could concurrency, you're going to pay impact fees, these roads are going to get done. But it has been almost impossible to keep up with that because you have to buy land, the process of buying land and going forward and building roads. You know, you're going to hear all kinds of people say, why don't we have these roads? We have started in a hole. You had impact fees trying to pay for everything. And then the impact fees haven't been raised in, I don't know, 5 years, maybe. I can't remember. They're supposed to be looked at least every 5 years. And so now you have a lot of bonding that's going on to pay for roads with taxes. That's a new standard. Pay for these bonds with property taxes, and developers get to pay and go. That's what it is. They say, this is my impact, here's a check, I'm done. So that's where that is at. Individual land development cases more difficult to challenge by citizens. Again, we talked about that rezoning, the quasi-judicial standard. Unless the citizens have hired to bring in experts, it's very difficult to challenge an individual land case. But comprehensive plans are still legislative. Your representatives, when they're acting to do a comprehensive plan amendment, they're acting in a legislative capacity. You can talk to them all day about it. You have the right to talk to them about what they're proposing. My guess at this point, I'll just close with this, is that Manatee County is going to have to start looking at changing the future development area boundary, right? And we've got these little pieces that keep changing it, but you got to look at it, the bigger picture, because, 1989, think about it, we've been able to exist with huge amount of growth since 1989 with the comprehensive plan as the way it was written. We don't have shortages now, but you can't piecemeal growth. I'm getting kind of opinionated now. That's okay. I guess I'm at the end, so I will. In my opinion, you shouldn't be able to just piecemeal it. You're going to have to look at this on a holistic standard. So get involved. I think, did we have something about getting involved? I can't remember. Seems to me we had something about getting involved. This is yes, good. Opportunities for involvement. This is where you want to get involved, okay? The county has a pretty good website. Manatee County has a pretty good website, lets you know some of the things that are going on. Hopefully they'll be able to keep it up to date. It's tough because you have so much going on. Workshops, sometimes they're not televised, but I would encourage you really to look at the county's webpage. I can tell you exactly how to get on it if you don't know how, and look for things. You can go and you can talk. And a lot of you know that you can go to the commission meetings and say, this is something that's happening. I've learned more about comprehensive planning. I want to know what's coming next. What is the next phase of comprehensive planning? What are you going to do? There used to be a group called the Planning Task Force that would meet. It was a lot of professionals would meet with the county staff and talk about changes that were coming forward. I don't think they've had a planning task force meeting in maybe, I don't know, maybe half a year, but that is an opportunity. That is a public meeting. They have to keep a record of it. It is in the sunshine. And we didn't talk about sunshine, but hopefully you all know what that means. That anytime that you have 2 or more elected or even appointed planning commission officials talking about something that come before them, they have to do it in a public meeting where the record is kept. Outside opportunities, there's different groups. Misty and I are both members of the Florida Planning and Zoning Association, have both of us served on that committee. It's a great thing to talk about with other, we're not alone in this. Manatee County, we're not alone. Other communities are facing a lot of growth. How are they handling it? The Chamber of Commerce has subcommittees. People can work on those. I've been on those. And the Manatee Association of Community Development, you can register, I believe, still with the county and get information about what's going on. So those are some of the outside opportunities for involvement. And that's it. We're going to open it up for questions. Hopefully we left enough time.
Yes,
Okay.
Thank you so much. We've actually had a lot of questions come in, so I think we'll get through as many as we can, and then we can make a decision how to answer the remaining ones. So the first question was just a clarification on the OPUG map that you showed at the beginning of the presentation, Betsy. Someone asked, what does EUA, UGA, UFA, and RRA stand for? They looked like acronyms with years.
Yeah. And Misty, if you know better than me, I was guessing. I was literally guessing because this map was something that someone gave me. I unfortunately did not have time to look up and see exactly what that was done in 1973. That was a map for services, utility services. So I honestly do. I was guessing that the RRA meant rural. Let me go back. Okay, I've had it. Yeah, that the urban fringe area, urban growth area. I don't know what the EUA meant. So I am guessing, quite frankly, that you have the rural area, that's the RRA, urban fringe area, 1982. So this is when services, so this is what it appears to me, and is the 1972, you had urban services there.
And EUA might be existing urban area as a guess.
Thank you. Yep. Thank you, Misty. That makes sense. And then you have 1977. This is what was planned for county utilities. It was an exercise how county planned for where urban services would extend to. And in 1973, this is their best guess out to that urban fringe area, that would be what they would need to provide urban services for. So in 1973, you had people beginning to, or the county leadership having grants to build water, sewer. And so most of what you have today are, as far as water plants, sewer plants, are actually located in that area, with the exception, obviously, Lake Manatee was created in 1957, is my recollection, same year I was born, that they created the dam and dammed Lake Manatee to make it a potable water source, which interestingly enough was because the farmers demanded it. They wanted all those northerners that were moving here to get off of their groundwater. So they're the ones that made sure that Lake Manatee was built. And I heard that directly from Bill Nixon.
Were impact fees or something similar a part of the early state planning and environmental laws?
Not really, not really. They didn't come into being. You know, it's interesting, when I was researching this in the 1970s, it's when they finally, you know, they thought that growth would pay for itself initially. And that's when, you know, Florida was mostly rural, right? And so you had this new growth, and now you have taxes that are coming in from this new growth. But they're seeing that the taxes, so much of our taxes go to things like schools and public safety. You really didn't have things like emergency services being able to be covered. But public safety, the sheriff, for example, takes a huge part of taxes. So then that started in the late 70s. They're realizing that growth is not paying for itself. And that's when impact fees started to come into being.
And were they initiated by the state or local governments?
They were initiated by local government. The state sets the law that you have to comply with, but you have to adopt them at the local government level.
Okay, thank you. Can you explain the difference between DRI and sector plans again?
Hey, Misty, you want to take this one?
Sure. So DRIs, as Betsy explained, the development of regional impact. Think of the outlet mall up in Ellington. That was one of the commercial DRIs, a place where people from the region are going to come. A sector plan is more focused. So, and like Betsy said, you saw those in areas where you didn't have a lot of DRIs. I think Sarasota has a sector plan along Fruitville, if I remember correctly. So it's just another tool for trying to manage the growth in an area.
And who can request the end of a DRI?
So again, I'll just comment on the DRI too. So development of regional impacts, the laws were created at the state level, what you had to do, but they were always prepared and submitted for review by the developer. A sector plan can sometimes be initiated by a jurisdiction, a municipality, a county. A DRI is always a development proposal. So yeah, there's a process in state law about how to abandon your DRI. Certain things can be abandoned, certain things not. I've participated in the abandonment of some DRIs, but a lot of DRI development holders will hold on to that because it vests them according to the rules that are in place. But yes, there's a process. You have to go through that process if you want to get rid of it.
Well,
Okay.
and the Heritage Harbor development is a good example. I think there were only 2 parcels left in that whole DRI. And they could have gone to the state and declared it to be essentially built out and gotten out of the DRI, but they didn't. They maintained it because there are some things, like Betsy said, that are going to help them with those last couple of parcels.
When Pat Neal was a senator, what was his legacy in the changes in the comprehensive planning?
Honestly, I don't know. Pat Neal, I think in the beginning, he was very pro-environmental law. Many of the environmental laws that were developed during that time. I can think of the wetland laws because I know this because I worked with Pat Neal on University Park Country Club. They had a wetland delineation that was vested, interestingly enough, so that they didn't have to go through the process every time they impacted a wetland. And again, wetland laws were largely developed at the state level through the Department of Environmental Protection at that time in the Water Management District, and he had a vested wetland determination back then. Now, whether or not he was involved as a legislator writing those rules, I honestly do not know. Misty, do you have any idea?
Yes, sorry, I do not know. I know that Pat used to be a Democrat and then became a Republican, which is interesting. And that's, if you know Florida history, there was a lot of that. Was he elected as a Democrat? I don't remember, but yeah, he served where I was in the planning world.
Okay. One attendee asked, how can the comprehensive plan be adopted without residents' involvement? They gave an example of how Port St. Lucie just had a citizen summit where residents had a say in every part of the comprehensive plan.
And Misty and I have been around for a long time, and we've been through many different comprehensive plan exercises, both in the public sector, the private sector. I can tell you when the 1989 comprehensive plan was developed, there were citizen advisory committees that were formed, environmental, transportation. It typically is a huge citizen involvement process. There's been updates. Some of you may remember there was something called How We Grow. There was also an exercise back, and again, I was in the private sector, that we went through and we decided where we wanted to see growth. So there have been significant planning exercises in the past, but that is up to the jurisdiction to do that. I think that I would assume if the county is going to go forward and do some of the things that they said, like they're going to change the future development area boundary, we've heard that there will have to be some input from the citizens. Again, it's the citizens document, but I don't know. St. Lucie is a very different county than Manatee County. And, it depends on who's in leadership.
Have either of you seen violations of the comprehensive plan, and what is the penalty for a violation?
Okay, so comprehensive plan amendments are appealable. And the standard for someone to be an affected party in a comprehensive plan amendment is much different than in a rezone. You don't have to be an expert. You have to be a citizen of Manatee County if you want to appeal something. You have to be of record. You have to be involved in the process to be able to appeal it, to get involved. But you can, and I would encourage anyone who is involved in the process, comprehensive plan amendments are done. They can be initiated by the county. They can be initiated by the property owner. If a property owner initiates a comprehensive plan amendment, it goes to the county for review. The county transmits, if it's a large enough one, county transmits the plan amendment to the state, who has very limited review. Used to be a big review, used to be a huge review. 2011, that changed, limited review. But it is that time at the transmittal hearing, you want to be of record, you want to submit comments, you want to go to the hearing if you can, and then you can also get on record by submitting comments to the state, whether or not it's complying with state laws. That is the process. but your best bet, if you're going to do that, is to make sure you know what the comprehensive plan says. And the staff report usually has all those policies written in it. So that is the best way. I don't know if I answered your question. I can't remember what the question was.
The question was about the violations of the comprehensive plan.
Oh, violations.
And there are some, but remember, it's all a matter of interpretation too. So, you know, I may interpret something differently from the way the staff interprets it, or the Board of County Commissioners interprets it. And that's why there is that appeal process.
The state can actually withhold funds from the county if the county does not comply with state law. There have been threats of that in the past. If you don't comply with new standards, for example, the state can withhold funds from the county. That is, and of course, you can do an appeal, you can file a lawsuit, all of those kind of standards. Yes, you can sue that there's non-compliance with state law, which is, state law does regulate comprehensive plans. So that would be the process, I think.
Okay, this might help. Another attendee asked that in the comprehensive plan, it said that there should be no development in the wetlands. Implementation allowed for wetland development with mitigation, even though the mitigation isn't effective. They asked, why is this allowed? And what is in place to protect our drinking water sources regarding zoning?
Okay. Take a stab at that. Again, wetland laws, generally what the county has is basically reflecting what the state requires, right? For wetland protection. The county does have a little bit more protection in the watersheds, the Lake Manatee watershed, the Evers Reservoir watershed. Additional buffering requirement that's been challenged in the past by developers, and it hasn't been, the developers have not won on that challenge. The county has won that they can provide protection, buffers, and limited impacts. So the way that the quality of those wetlands is calculated is defined by the state, and depending on the quality score that those wetlands get, there can be impacts as long as there's mitigation. Again, it's basically all laid out under the Water Management District, and the Water Management District also implements the Department of Environmental Protection regulations for water, for wetland protection. So it's a state law that is implemented by the county in compliance with that. Because the development would see, so it's again something that has transitioned. It used to be that it was so onerous that you almost never impacted a wetland. Now, if you have a road that needs to cross through a wetland, it is not as difficult because the requirements have changed. Misty, your thoughts on that?
Yeah, I mean, great job. And I don't think the comp plan prohibits the impact of wetlands, but like Betsy said, it wants you basically to protect it requires the protection of the very valuable wetlands with limited impacts, and that's further defined in the.
Misty, could you repeat what you just said? The sound cut out and I couldn't hear that last comment.
Yeah, so basically, wetlands are very important and they are protected by the comprehensive plan. But a wetland along the coast or one that's forested is going to be much more valuable than a little tiny wetland that maybe was farmed and no longer supports habitat or plant life. So not all wetlands are the same, but the important, valuable wetlands are protected by our comprehensive plan with very little impacts allowed.
Thank you. I'm going to ask a couple more questions, but I am not going to get to all of them within our time frame. So would it be reasonable for me to let everybody know that the questions that are coming up in chat, we have them, and I will save them and work with Misty and Betsy to get answers to all the folks who are asking them that we can't get to in our time today. Would that be okay, Betsy and Misty?
Yeah,
Yeah,
that's fine.
okay, thank you. So the next question is actually about a case, the Conservancy of Southwest Florida versus Collier County. It was a case that Misty posted about on Facebook that one of our attendees saw the post. And they asked, does Manatee County require that growth must be fiscally neutral or positive in the Land Development Code or Comprehensive Plan?
There used to be fiscal accountability, as Betsy touched on her presentation, but I don't think the state of Florida requires that anymore.
Yeah, I'm not aware of that. The ability, there's really no submittal of any kind of fiscal neutrality type information. It was required in some of the larger projects, the DRIs had required that at one time. That, to my knowledge, there is no law that requires any kind of fiscal neutrality in Manatee County. If other jurisdictions have that, that would be interesting to know about. And I assume that's an optional, something that a jurisdiction can do. Typically, unless it's prohibited by state law, the local jurisdiction has a lot of latitude what they want to put in their comprehensive plan. They can put whatever regulations basically that they think are that development should meet, as long as they're reasonable. You know, don't go over any of the standards that we talked about, and that you could have those kind of standards. So it's possible that that kind of fiscal neutrality. I remember trying to come up with ways to meet that fiscal neutrality, and lots of times it'll be discussed, and even in Manatee County when we're discussing impact fees. You know, who pays impact fees, who pays taxes. New development pays higher taxes than existing development, right? So yes, there's lots of times you'll, even when we get into the impact fee discussions, you'll see different experts talking about fiscal neutrality, but that's the only time I can think of that it's discussed in Manatee County.
Okay. And is there a specific state department that's in charge of comprehensive planning, or that planning plans get submitted to?
Yes, Department of Economic Opportunity is the department that, and again, I would encourage anyone to read the staff report and comprehensive plan. You can learn a little bit. They have transmittal letters to the Department of Economic Opportunity. It'll reference the Florida statute that they have to comply with. The comprehensive plan also, Manatee County talks about your coordination that you have to have with the state. So yeah, that is definitely still done at the state level. Very different than it used to be. The Department of Community Affairs, some people might have been around long enough to remember that was the department, and it was a much larger department. Now this is a smaller part of the Department of Economic Opportunity at the state level.
There have been a few comments around the usefulness of publics coming to meetings and speaking up and trying to impact the comprehensive plan. And so one person asked, how can you get new priorities addressed in the comprehensive plan? And how does data like number of car crashes or the health and safety of those in that area get taken into account in order to create changes in the plan?
I'll take a stab at it, Misty, you can too. So again, as I said, comprehensive planning is a legislative act. Not too terribly long ago, there was a process where the planning commission is required by law. They're called the local planning agency. The law requires that you have one. So their role is much more than just considering rezones. So there used to be a time when they would meet for a half hour and discuss bigger planning issues. You could go to the planning commission and say, you're the local planning agency. I'm seeing all of this happening. It's not addressed in our comp plan. What do you think? And then you could do the same thing, obviously, at the county commission. But don't forget, that's what your local planning agency has a role. It hasn't really been implemented recently that I know of. We've seen a lot of changes in staffing and how things have been done in the last couple of years, but that was, some of you may remember, Misty, you have thoughts on that too?
Yeah, so how do you get new priorities into our comprehensive plan? I would say the most fundamental thing is to remember that elections have consequences. So the people that you vote for at the state level should carry your same priorities or listen to your priorities to earn your vote, because the state is still telling the counties what they have to do in their comprehensive plan. And then you go to the state, to the local level of elections, it matters. Make sure that you're electing people that have the same values that align with yours. And then now I mean, if you just look at who's in office now, you as a citizen have the right to go to your elected officials and say, look, I think that we need to increase requirements for this or decrease requirements for that, and have a voice and tell them what you expect, because you are their boss. So that's how we get new priorities. As for the data, a lot of it is just population driven. I think of the Metropolitan Planning Organization, which is a regional planning group that focuses on transportation. And in the example of how many accidents and different roadway safety issues, they're focusing on that as well. So how do you get new priorities? Get out there and have a voice and organize and get more people to understand and speak up.
And I'll offer the League's Social Issues Action Team meetings as one place to come together with other community members who do want to work together to create some change. So if you're interested in coming to a League of Women Voters meeting, please do, and share your voice with us, and we'll do what we can to support and work together. I do have about 15 more questions at least that I have not had a chance to ask. There was a lot of wonderful conversation and comments and questions that came through, but I do recognize that we're at the end of our time. So I want to thank both Misty and Betsy for their wonderful presentation. It's really helpful. I got a lot of comments about how helpful it is to understand the history, and everyone who did come and participate and offered their questions, I thank you as well too. And I look forward to seeing you at future League meetings. And I did have some requests for a part 2 training. So Misty and Betsy will also talk to you guys about having something in the future to continue this wonderful education and conversation. Do either of you have any final comments before we close?
I just want to thank the League for this, and thank you for inviting us. And I'm always available. You can Google and find my number. If you have a question and you want to call me, feel free.
Yeah, I was going to say the same thing, Misty. I mean, you can contact me, on Facebook. You can contact me however you want. I'll be happy to try to answer your questions as much as I can. And I really appreciate Misty's, giving everyone, this is your comp plan. This is your community. Be involved. And the best place to be involved is the comprehensive plan. Used to be people didn't pay attention to it. I think people are paying attention to it more. And that's a good thing, because that is where you have the opportunity to be involved, is in your comprehensive planning. So.
Thank you, Alice. Or